A major ruling from the Supreme Court today, one that strengthens the financial rights of divorced Muslim women in India. The court has held that a divorced Muslim woman can recover her dowry and gold given at the time of marriage, reaffirming that these assets belong to her and must be returned. The landmark judgment overturns an earlier Calcutta High Court order in a case involving Roshanara Begum, married in 2005 and divorced in 2011. At the time of marriage, her father had given her husband 7 lakh rupees and around 360 grams of gold, all recorded in the Nikah-Nama. The High Court had dismissed her claim, citing contradictions between the Qazi's testimony and her father's statement. But the Supreme Court ruled that the Qazi's evidence and the original marriage record cannot be brushed aside simply on suspicion. The bench said Section 3 of the 1986 Muslim Women Protection of Rights on Divorce Act must be interpreted through the lens of dignity, equality and constitutional protection for women. The court made it clear property given at marriage is for the women's security and she has the full right to reclaim it after divorce. The Supreme Court has now ordered the husband to deposit the entire 7 lakh rupees and the 30 bori of gold directly into the woman's bank account. A powerful judgment reinforcing both legal protection and financial justice for divorced Muslim women. While in a significant development, the Supreme Court has granted relief to Benazir Heena, the woman who has challenged the constitutional validity of the Islamic practice of divorce known as Talaq-E-Hasan. The top court has accepted her requests and directed her husband to pay 10,000 rupees per month towards the child's expenses. The court has also passed orders on the issue of father's consent for the child's Aadhaar. In a strong directive, the court has instructed the school where Heena sought admission for a child to grant the admission without delay. In the previous hearing, the bench had expressed clear displeasure over such practices. In fact, the court had posed a pointed question: can such a practice be permitted in any civilized society? Talaq-E-Hasan is a form of divorce under which a Muslim man can repudiate the marriage by pronouncing talaq once a month over a period of 3 months. The matter may now be referred to a constitutional bench, signaling a potentially larger reconsideration of this practice. The case was filed by Benazir Heena, who told the Supreme Court of India that even after triple talaq, which is instant divorce, was struck down as illegal, many Muslim women continue to suffer because men are now using Talaq-E-Hasan, often irregularly and in collusion with religion or legal authorities. According to Heena, this form of divorce has been misused. Unilateral divorces are being handed down without due process, leaving women and children in limbo with no maintenance or support. The procedure mandated under Talaq-E-Hasan also comes under scrutiny. As per law or tradition, the divorce pronouncements must be 3, spaced a month apart, but in many contested cases, the Supreme Court was told that pronouncements are being misused, sometimes bundled together or effected via third parties, which infringes upon the procedural safeguards. In a 2017 landmark verdict, the Supreme Court struck down triple talaq as unconstitutional, and Parliament later criminalized it under the Muslim Women Protection of Rights on Marriages Act 2019. Talaq-E-Hasan may now be the next in line to undergo a constitutional validity test.